whoever's watching this, you pay good money every month, every quarter, every year, and you expect something in return. I mean, you're paying this money that you've earned, and you better get something in return. And what the association is giving in return is to comply with deed restrictions, because you live in this very specific community where everybody has to play by the same rules. And then also, they have to enforce statutory rights. And this is where I think the recordings becoming official records are a very big game changer for the long term, for sure.
I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hello and welcome back to Bad HOA. Today we have a very special topic, a very special guest. I'm Luke Carlson. As always, we have Marty Vasquez. Welcome.
Thank you for having me. It's good to be back as usual.
Well, great to have you. And we have a very special guest zooming in from Florida, Jeff Kominsky. Welcome to the show. Managing partner, head honcho. Welcome.
Thank you very much. It's really great to be back. I know that I've done this a few times now. I've gotten some great feedback from many people just wanting to be informed about how they can help improve their associations and make sure that everybody's being held accountable, whether it's the association, board members, or even their own neighbors. So I really feel like this is hopefully going to be even more helpful for people out there.
You know, I'll speak to that, Jeff. We get a lot of some of our most engaged episodes come from the episodes with Jeff in them. He always brings such wonderful content, and it gets a lot of positive responses.
Well, homeowners in Florida, I think in particular, you know, there's so much movement from a legal standpoint.
Yeah.
And this specific episode, going over the changes in the law 2025 and some really nuclear things happen or being proposed in Florida, this is what homeowners are looking for. And, you know, to have Jeff as a resource, as just a tremendous legal mind coming in, it's always well embraced and well received.
Yeah. And you know what? I'm always so impressed too with just hearing about the stuff that's happening in Florida, because they really do feel like they're on the bleeding edge. A lot of people, I feel like in a lot of states, they see what happens in Florida, and they're really, I think after Surfside, the tragic incident in Surfside, they've really taken the legal standpoint of that very seriously and passed a lot of legislation that I think is very beneficial across the board. So it's always interesting to see how they continue to push the envelope and be a leader in the rest of the states.
Well, that's a great starting point, I think, Jeff, for you. The question is, are you seeing that sort of homeowner empowerment, right? We've seen it in California. We had AB 130, which was very much pro-homeowner. And it seems to me, from California's take, Florida keeps getting stronger and stronger when it comes to empowering homeowners, protecting homeowners. Could you speak to that?
I think that's is a good of way to say it. The last few years, Florida has been a state that the whole country has been looking at. And it's because of the fact of a few things. One is Florida is one of the largest states per capita with associations as a whole. So they want to see what are the basic standards that Florida has implemented on all these thousands upon thousands of associations. And more importantly, is it working? What we found is in the early 2020s, after post-COVID, with the tragic events of Surfside, and also with a lot of discovered fraud in various areas and pockets of Florida, the state decided that there needed to be more transparency. There needed to be more accountability. And so what we've seen really post-COVID is a stemming of the tide in terms of association power and withholding of information, and really this tidal wave of interest, information, and rights that property owners, specifically condo owners and single family homeowners, have had that they never had in recent years. And so 2022, 2023, 2024 were all progressive years to promote individual owner rights. And 2025 was no different. And the laws were passed and then signed by the Florida governor, Ron DeSantis, to be effective on July 1st of 2025. And really, I hope we're going to get into some of the interesting, small but impactful things that have changed in favor of owners in just 1 year alone.
Well, I say we jump right in. I mean,
Absolutely.
let's just start right with what is law, or what are we looking at? Let's start current, and we'll make our way forward.
Yeah. So I think one of the most important things that people need to know is when it comes to 2025, there was this House Bill 913. And House Bill 913 went through the legislative process and ultimately was, once again, voted on, signed on by the governor, and codified. So when people just say, "Hey, Jeff, but what happened with what about House Bill 913?" It's no longer House Bill 913. So I think the first thing I want to make sure people understand is when we talk about new laws, it's not necessarily House Bill 913. It's what actually was codified
Right.
from that. And really, there are 3 Florida statute chapters that were directly impacted. Okay. The first is a Florida statute chapter regarding property managers. Okay. And this is a pretty important thing to know because 2025 was a banner year for making property managers more accountable. Okay. And we'll talk about that. The second Florida statute section is with regards to condominiums. Okay. So if you live in a single family home, that is not this House bill did not impact you at all. Okay. You would have to revert to the laws that were relevant and enacted in 2024. Okay. And then the third is regarding cooperatives. Okay, they're kind of the hybrid middle child, if you will, between Florida condominiums and Florida homeowners. I will tell you, I'm probably not going to be talking about cooperatives too much on this podcast in the sense that a lot of what happened in 2025 legislatively for condominiums basically was mirrored to cooperatives. So what was good for the goose is good for the gander, so to speak, when it came to condominiums and cooperatives in that respect.
That's great. Well, let's first jump into the property managers, the increased like legal exposure on that front. Let's dive into each one of those things individually, Jeff. If you want to like laser in and kind of tell the people, like, okay, in particular, property managers, what happened there? What can we expect? What homeowner empowerment mechanisms were put in place that the homeowners need to know about?
Yeah, and we see this in California, Jeff, quite very frequently, where you have an association and a really, really bad property management company that is just destroying a neighborhood. And so the fact pattern is very common in California. I know it's very common in Florida. So maybe walk us through, okay, before this law came into effect, this was the situation, but now here's how it's different legally for a homeowner.
Yeah, absolutely. So when it comes to property managers, I think we first need to look at what the Florida statute chapter is for property managers, which is Florida statute chapter 468. Okay. And 468 for a long time has just generally said what things a property manager has to do, what licensure they need to obtain, that kind of thing. When it comes to association relationships, 2025 was pretty important because one of the continued concerns that associations and even property owners were facing was this merry-go-round of property managers. That 1 year there's a property manager, next year not so much. Okay. And so one of the things that was pretty critical in terms of this merry-go-round was associations were entrusting a lot of protected information, records, daily functioning in terms of communications, really delegating it to these property managers. So what happens when these property managers had to leave or they were fired? I will tell you, a large percentage of the people watching this podcast probably can raise their hands and say, absolutely. I have 2 or 3 property managers that I've had to learn their names and email addresses. But what happens when these property managers move? A lot of times in the last few years, we've sought records on behalf of our clients, and the associations will say, well, look, we gave them to our prior fired property management company. There's really nothing we can do about it.
Mm.
And that is a problem for the association, but now the association actually can help out the property owner, because what the 2025 laws did for property managers is to hold these terminated or fired property managers accountable. That they have to, upon termination, within a certain period of time, provide these records that are actually the records of the association
Mhm.
back to the association. And if they don't, there are some significant consequences. So I do think that it does, in a sense, allow the association more protection to recapture their records, but it also helps the homeowner because now the homeowner isn't kind of felt that unable to
Right.
acquire the documents that they need to actually prove what the association, what the board members, what their neighbors are just not doing right. And obviously the association needs to fairly and equally enforce all of their provisions of their governing documents, comply with the relevant statutes. And so this is a pretty important piece of the puzzle to make sure there's the evidence that is a property owner is allowed to get access to.
Well, with this change, then the association would have more firepower to get those documents. Because I'd imagine before it was most likely a contractual basis, right? Because the management company is a vendor, they have a contract, and maybe there was some verbiage on turning over the records after
Yeah.
termination. But this would give a statutory basis for an association to put pressure on the management company to comply. Is
Yeah,
that
so for a correct. So for a property owner, this isn't a new right the property owner has, but this is very helpful for the property owner to ensure that they can get access to the records that they are entitled to, and it gives the association that firepower,
Yep.
as you just said, to act on that. So it actually helps the association get the records they need, but more importantly, it really gets back to the property owner who is legally entitled to those records to begin with.
Precisely.
So Jeff, let me ask you this: is once they fire a property management company, are they required to give over all the documents that they have, like right away, or is it there's a certain window where if they request it, they need to comply within a certain amount of time?
Yeah, it's the latter. There's a certain window that they need to comply with a certain amount of time, and then it gives them the association, the statutory right to escalate against their fired employer, not just contractual in nature. So to Luke's point, most property managers are independent contractors or vendors. They're not necessarily employees of the
Mm.
association, and so usually there is a property management contract, which, by the way, every property owner in Florida is entitled to see that and access that contract. So not only are they the association and probably entitled to escalate in terms of contractual rights, but now statutory rights.
That's wonderful.
That's
That's so
interesting.
powerful. I mean, you run into so many
Absolutely.
situations where, yeah, the association buries its head, say, hey, we don't have it, not our problem. Talk to the management company. But it's so frustrating from the homeowner because the homeowner now goes to a management company. They get, they're on the endless phone tag or, they're for following up. No one follows up with them. But this actually gives some real teeth.
Well, I think too, it could probably remove several disputes because what we've always said is the ultimately if the property management is messing up, it's the board's. Ultimately, it falls back on the board.
The buck stops with the board.
The buck stops with the board. So if they remove said property management company and the homeowner's trying to get some sort of documentation by way of the board, but they're not complying, they're doing everything that they can, and at least now that they have some legal teeth.
Well, they have some strong leverage
Yeah.
into it.
Yeah,
So that's
I
great.
like that.
All right, that's property management. What should we go to next, Jeff?
Yeah, so I think
Next
we
big
definitely get
topic.
in. Yeah, next big topic is definitely Florida Statute Chapter 718, which is the Florida Condominium Act.
Mm.
Okay. And this is the one where I feel where 2025 really benefited property owners. And once again, very small changes, but very impactful changes
Mm.
to property owners. And one area that I probably want to start with in particular is official records. Okay. So, as we were just talking about, these records that now terminated property managers have to give back to the associations, these records are written records that relate to the operations of the association. And there's a specific statute in 718. It's Florida Statute 718.111. Now, it's a very long statute, and whoever is watching this podcast may have read it entirely. I usually tell people that if you are sleep deprived, read the entire section. But if you are not losing sleep, about halfway down, there's a specific section called official records. And what the Florida legislature did in 2025 was to beef up owner rights by promoting transparency in many respects when it comes to official records. Okay. One of the things that it did was it tried to keep up with modern technology. And the Florida legislature realized that a lot of meetings, condo board meetings, are now conducted via Zoom. Okay.
Yeah.
So for years, it was always that records had to be written records relating to the operation of the association. That's a lot of the pushback we had gotten post COVID. Okay. But what this Florida legislature did is say, hey, look, if board meetings are being conducted via Zoom, how do we memorialize that? So now what the statute required is now all Zoom meeting recordings of public meetings, like board meetings, are, even though they're not written, they are now considered an official record of the association. So this avoids the potential issues of who said what during board meetings, especially on the grounds that board meeting minutes are notorious for not being thorough, for not being accurate, and for more in favor of the drafter than anybody else.
Right.
And there's no requirement in Florida of how board meeting minutes need to be taken. It's just not a thing. And every association's different, but now there has been this uniformity that now solidifies and I think really protects property owners, because now if they're entitled to recordings of board meetings, and board meetings can get heated, we all know that. But now instead of a he said, she said, or he said, or they said, whatever pronoun you want to use, at the end of the day, it's recorded. So we don't have to rely on what people's memories are. And so I do think that that small change is one of many changes that I think that condo owners should really appreciate, especially if they attend board meetings. They can now know without fear that they're going to be able to get the transparency they need, because people are going to be more accountable for what they say at meetings.
I love this. I love this so much.
Yeah.
So
go ahead.
So the question I have, Jeff, is, recording on Zoom is optional, right? Like when you're going on Zoom. So does the law require them then, if they're going to do it by Zoom, that it does have to be recorded?
I would tell you my interpretation of the statute would be if it's proposed to, because sometimes the meetings are in person or Zoom, right? But I would tell you that as a matter of law, and it obviously hasn't been tested in court yet, I would tell you that the implied argument that any Zoom meetings have to be, the recordings are official records, probably means they have to be legally recorded if they are proposing it via Zoom. Now, that does not mean and make no mistake, I do not believe this says that all board meetings have to be proposed or offered via Zoom. A lot of associations are very small, don't have the capabilities, don't have the space, don't have the technology, for whatever reason. So I don't think meetings are required to be virtual or via Zoom. But especially, I think it's been more embraced in Florida, where you think about, snowbird season on both the east side of Florida, the west side, Naples, Tampa area, where people just don't live in Florida full time.
Mm.
I think it is very helpful for people to attend board meetings via Zoom, and people more than ever are really attuned to what is going on in their communities,
Mm.
which is, I think, a great thing because you all, whoever's watching this, you pay good money every month, every quarter, every year, and you expect something in return. I mean, you're paying this money that you've earned, and you better get something in return. And what the association is giving in return is to comply with deed restrictions, because you live in this very specific community where everybody has to play by the same rules. And then also, they have to enforce statutory rights. And this is where I think the recordings becoming official records are a very big game changer for the long term, for sure.
Mm.
Yeah, when I first read this, I was just thinking about the level of transparency and how strong that is, because often you have these board meetings where, they're used as a form for harassment
Mm.
or, mistreatment. And if you look at the records, though, it's the same person who's doing maybe the mistreatment that's taking the record, the official record.
Yeah.
But now when you lift that sort of ambiguity and you force a recording or you mandate a recording, I mean, that's true transparency.
Yeah.
And one would hope that the boards would be on their best behavior, if
Sure.
they know that this is being recorded. This is now part of the official record. So I see it as a tremendous win for the homeowner.
Yeah, but even if the person that is taking the record is the one with the malfeasance, let's even the board secretary that's part of the board,
Right.
The board can kind of protect itself. I love the fact
Right.
that there's some transparency in the mix here. I think that's tremendous.
Yeah, it's a huge win, and this becomes. I mean, it's a huge magnitude of change for the homeowner.
Yeah.
With something like this.
Yeah. That's great, Jeff.
Absolutely. And to just kind of supplement this section of official records, um, the Florida legislature also felt like they had to address the concerns of financial fraud going on in all of the state of Florida, particular in South Florida. There were a few really big public cases involving financial mismanagement, financial fraud, at least those allegations, one of which was called the Hammocks community. It's one of the largest communities in all of South Florida. And so to kind of react to it, if you will, the Florida legislature also included some financial records, is specifically and explicitly including now bank records. Even though I was always under the impression I would always ask for them anyway, but now it was specifically added so that associations couldn't say, oh, well, we're only entitled to give you the budget and annual statement, that kind of thing. Now it's bank records as well.
You know what I love about this is the fact that if they don't give you the bank records is such a red flag.
Oh, 100%.
You know what I mean? Like, they're like, we are not required to give you the bank records. We can give you all the stuff that the law tells us, but like, what do you have to hide?
Right.
Like, that's just telling you the other side, we're not being transparent
Well, I
on
think
purpose, which I can't stand.
What it also is showing, though, is how much Florida has its finger on the pulse
Yeah.
of the gamesmanship. I mean, because what we're talking about is very nuanced tweaks that have huge impact for the homeowner. I mean, just adding, the bank records
Yes.
in the code, codifying that. Someone must have known firsthand that this someone was playing games,
100%.
and let's just clean that up.
Yes.
And so I can't say this more, or I can't say this enough. It's such a win for the homeowner.
Yeah.
And they're
Yeah.
small,
and-
but they have huge impact.
Yeah, and to that point, this kind of is a furtherance of prior years where Florida law in the last 2 years required that before the inspection that the association proffer a checklist of the requested records. So, because what was happening is people would walk in on business day 10, because the association's allowed 10 business days to provide access. On business day 9, they'd say, oh, you can come tomorrow morning. The person would come on business day 10. and person would say, "Hey, association, I'm here. Where are the records?" "Oh, well, I guess we forgot, or I guess the records are in all those banker boxes over there." You can spend the entire day sifting through it yourself. And so, the Florida legislature appropriately said, okay, we need to make things more efficient, more transparent, and make associations more accountable to these records. And so, not only did they require checklists be given to condo owners prior to inspection, but they also said that if, and I'm paraphrasing from the statute, but if certain financial records are intentionally not provided, there would now be legal criminal consequences.
Oh,
And so the Florida courts are sifting through that process right now. There have been a little bit of bugs from a practical and procedural mechanism of enforcing it. But I do find that, especially in the last 2 years, with 2025 kind of upgrading the last version, associations are much more inclined to give you access to the records that you've requested. And so when it comes to adding bank records, imposing records that relating to structural integrity reserve studies or SIRS, there's definitely been some more openness and provided more accessible rights to property owners and condo owners specifically.
yeah, love it.
So
It's
good.
Yeah, it really is. Like I reiterated at the beginning, just Florida leading the charge with these little tweaks that are huge wins for the homeowners.
Well, it seems more and more that they're buttoning down.
Yeah,
Right? They laid a fantastic foundation, but now, like you're saying, they're fine tuning it,
yeah,
and it's almost as if they're monitoring and they're seeing how the boards are sort of wiggling,
yeah,
and then they sort of identify these smaller issues. Now they're very small tweaks, but again, it's slowly putting more and more pressure on these boards, these bad boards,
yeah.
to engage in transparency, to comply with the law, and limit the amount of maneuvering that they can do in bad faith, which
Yeah.
is often bad faith.
Yeah.
And one of the suggestions is, or a pro tip for people watching this, because if you're watching this, you might not realize certain things, or you might have already researched some of this. But one of my pro tips always is, before you seek out official records, that you see if your association has a website or a portal. Because once again, trying to catch up to technology, there have been laws, especially in Condominium Act, that now require certain associations to have websites or portals, post records that are very specific online. Not all official records have to be posted on the website, but there are even records that say that once a record is established, a certain record, it has to be posted on the website within 30 days. That's a new 2025 change. So condo owners need to first go to their website or portal to see what records exist, and know that if the association has been lagging on certain records being posted, and they know, for example, these records were created more than 30 days ago, I think that you can hold the association accountable. And having this website or portal is important, because you want to be time efficient and financially efficient before you seek out records that the association simply responds, "Hey, did you check out the portal or the website?" Because there are a lot of records that we find that the association has posted. But rest assured, I do this for a living. I do this every day. I have not come across a single association in Florida that has posted all the necessary records on their website or portal. So just be mindful of that. Maybe that's intentional, maybe it's not, maybe it's violating your statutory rights, but this is where you need to hold them accountable and make sure they're posting the records that are required to be posted online, and make sure you seek out the records that are not necessarily required to be posted, or they're not posted and they should be.
Jeff, briefly, just from a tactical perspective for homeowners, we're talking about pro tips. So let's say you're a homeowner, you're seeking a number of records, not on the website, or some are, but a vast majority are not. Mechanically, how does the homeowner approach the association? What is the methodology to actually request those records?
So if you find that there are records not on your website or portal, okay, and you believe you're entitled to them, one of the first things people do is they do what they were told to do, which is email the property manager. Okay. "Hey, property manager, Happy Thursday. I hope you're having a great week. I'm just trying to not rustle any feathers, but I would like to see all the notices of violations towards everyone in my community over the last 7 years. Sincerely yours, Jane and John Doe. Okay? That email, while nice and appropriate and to a property manager, just like the association told everybody to do it, will go legally nowhere. And the reason why it'll go legally nowhere, I mean, I hope I'm wrong. I hope property managers will comply. But, once again, I doubt that many people watching this have those property managers that will say, hey, sure, here are these records, not a problem.
They're probably not watching a
Um,
bad HOA podcast if they have a good
right.
HOA.
Yeah. Oh, and they're responding timely within 10 minutes, asking about your kids. No, that does not happen in life. Okay. So, in order to really hold your association accountable when it comes to these records, generally need to go through a step process that is very specifically identified in Florida Statute Section 718.111. Through a certified letter to a registered agent, identifying the statute section. Those are kind of the three basic hurdles you would need to jump through in order to trigger the statute. And I'm going to tell you, that's usually what you need to do, because otherwise, they can take that nice Thursday email you sent and never respond.
Hmm.
And they can keep it in their inbox. Maybe they read it, maybe they don't. But legally, then you get frustrated because they haven't responded. And the legal reality is they don't need to. So just know that you do need to comply with the requirements as set forth in the statute to trigger the statute. And there are significant legal ramifications now, especially in the last few years, that the legislature has put on as safeguards to hold your association accountable for this very simple step of getting access to records.
Got it. Thank you for that, Jeff. That was really good.
Yeah, interesting.
All right, so where do we go now on our journey of new?
I think that one last thing, just to very briefly touch upon it, because one of the main things that this House bill did try to do, and it doesn't affect a lot of people that we come across, but when it comes to structural integrity reserve reports, I think I can't do a 2025 legislative update with at least saying out loud that part of the reason why they needed to make an update is because the legislature found that a lot of associations, condo associations, were not able to comply with the time restrictions of these SIRs, of these reports. So there was some breathing room given to associations. And part of it was because in order to create a report, you need to get an engineer to come out and see the property, go through their due diligence, and go through the proper steps. And what was happening was part of it was there weren't enough engineers. And so that basically created this practical problem of, well, there are significant legal ramifications if we can't get this done. But, imagine going to the longest Publix deli line imaginable. I'm the 153rd person waiting for a Publix sub. I'm not going to get it in time. And that's the ultimate problem. And that was a kind of a Florida reference.
That was a very good Florida reference.
Yeah, there you go.
No Publixes in California. But
amazing subs, though. Amazing subs.
Oh, the best.
Worth the
wait. For sure. So, but long story short, I only say that to identify that the statute did try to extend the time to ease the pain of the people waiting at the back of the line.
Understood.
And again,
so yeah,
Florida common sense. Like they saw this is not practical because there's a clog in the machine. in the chain or along the line, and they made some course corrections in order to facilitate it actually being practical.
Yeah, it's an adjustment based upon boots on the ground.
Yeah.
So
yeah,
very good.
And it comes with limited exceptions, but generally they identified this problem and try to help out those who are actually trying.
Understood.
Yeah, love it.
All right, where next, Jeff? You got the lead over on this.
Well, I think that's a lot of what I wanted to cover in 2025. I mean, we're already, into 2026. And so, from my perspective, I'm kind of prospective in trying to figure out, how we apply these laws and um, enforce condo owner rights. And now all of a sudden, the end of 2025, there was this proposed House bill. And this proposed House bill has, I think, really shocked a lot of people in the industry. It's specifically House Bill 657. And there is at least the current version as of this podcast is February 17th. Um, but it's still going through the legislative process. But as currently worded, there are a few very significant things that I think people just need to be aware of the potential significant changes that could be coming down the pike.
Well, we felt these shockwaves out in California when this first went live. I mean, when the news media picked this up, this was sensational, and I think rightfully so. And to your point, what it's seeking to do, in some ways, is a very nuclear situation. I mean, it's so drastic and extreme, but it's definitely worth talking about. And I'd love to get your input on it, Jeff.
Yeah, so I will tell you that a state representative put this out there, and part of the intent was to try to ensure that fraud does not continue throughout the state. And a lot of people are just very frustrated with their HOAs. They don't like that certain things they have to pay for if it doesn't necessarily affect them. And I think some people are disenchanted with the idea that they can actually resolve disputes in an amicable and collegial way with their communities. And so that's why this bill was presented. There are two or three pretty significant things in this bill that I think people need to be aware of, at least once again, current day. These things might be stricken, or this bill has not been signed into law, it's not effective, but it's going through the process. And one of those things that would change if everything remains the same is that the statute, if implemented, would basically no longer require mediations in a pre-litigation or pre-lawsuit perspective. So take it a step back or two, a mediation is a private and confidential meeting where both sides sit and try to talk it out. And in the middle is a mediator, a former judge or someone who's experienced in the law, and tries to make sure both parties understand each other. They don't have to necessarily agree, but I will tell you, a lot of times there are resolutions, there's agreements, there's ways to not try to file a open and public lawsuit that could be very expensive, time consuming, emotionally draining.
So,
And
Jeff,
so
to that point briefly, just so the homeowners understand, in this context, it's where a homeowner has a dispute with the association, and instead of jumping to full-blown litigation, court intervention in Florida, it's required to first go to mediation, depending on the dispute. But for the vast majority of these disputes, mediation is not only encouraged, it's required. And so it forces or channels these disputes into an informal context before the parties actually go full litigation. And that's the current state of Florida.
But actually, that sounds incredibly reasonable, but as a law.
Well, Jeff, we were talking about this before the show. Your take on mediation, and it's also our take in California, because we have a very similar infrastructure. It becomes a very beneficial forum to actually get these disputes resolved in an economic way, but also within a relatively short timeline.
No, absolutely. I think once again, people in these disputes, which candidly are very emotionally charged, are concerned that the other side is not going to hear you, or the other side is not sympathetic, or the other side just already has such disgust for you that there's no way that they can try to resolve their differences with you. And I'm going to tell you, when it comes to a legal proceeding, because that's what it is legally in Florida, it's a legal proceeding in Florida, people change their tune. I think people realize that this is serious, significant. You've required them to appear within a time limit to try to talk things out, with perhaps the only alternative subsequently to file a lawsuit. And from an association perspective, if there is no resolution and a lawsuit's filed, how does that look
Right.
upon an association? Now all of a sudden, it's now known openly to everybody in the world, whoever wanted to see potential new buyers, that there's these issues that might not have been known, but for a resolution,
Mm.
or only because there was no resolution. And so I think mediation, once it actually occurs, the theory versus the practicalities really kick in.
Jeff, what's your opinion on why you believe that provision is being proposed for removal?
So what it's trying to do is remove it, and instead have a state-funded court system that is kind of segregated from the current state court system in Florida, where they only oversee association disputes.
Mm.
There are a lot of practical, logistical concerns about that. Who is going to preside over these cases? How are they going to preside? What's the procedural posture? Are they going to apply certain rules that are in courts, even though this is not a court technically? But I think just from a kind of a big picture perspective, kind of a taking two steps back from the elephant, if you will, this is going to be adversarial. And I believe that that's not what people want. I think people want to be heard, but to have a winner and a legal loser is not, in my opinion, the best first option to reconcile. I think that from my experience, I know that when there is reconciliation, people like to start from scratch. I mean, this isn't, a situation where you, God forbid, slip and fall somewhere and you never have to go there ever again because you're worried about ever going there again. This is where you live. This is where you bought a property to use and enjoy and have community and socialize. And now all of a sudden you become the pariah, all because you wanted to enforce your rights. And now you're going to have a decision maker tell you who's right and who's wrong right out of the gate. I can understand that if that's the case as a last resort, but in my humble experience, mediation works. And I like the idea to try to promote alternatives, but I do think that this, from a holistic perspective, would have consequences that maybe aren't completely thought through.
You know what? The first thing that occurs to me is, I mean, just generally speaking, how backed up the court systems can usually be. And you're saying now it must go through court. And if they get that wrong in terms of staffing just alone, can you imagine just a dispute that could go, well, you're not going to have your day for 2 years or whatever the case may be. It could be, this thing could drag on a lot longer, where mediation takes that immediate pressure off of the court system.
With mediation, Jeff, I'm sure you've seen this. I mean, even before mediation, these cases can be resolved. The mediation demand goes out, the parties start to talk, or at least the attorneys start to discuss. And even before a mediation, you can get a resolution. This is really strong arming, homeowners and boards right into the gladiator's pit almost immediately.
Yeah. So there's two thoughts. So first is, I do find when if we represent a client who is offering the pre-suit mediation and the association or whomever accepts it, there is that opportunity to try to work things through to avoid the mediation. Absolutely. It saves time, it saves fees, and it gets probably a good resolution. The other component to it is that in their infinite wisdom just a few years ago, as it applies to condominiums specifically, the prevailing statutory thought was that certain disputes have to be only going through a arbitration process. And this is a state mandated arbitration process. And arbitration, just so people can understand, is already kind of, in my opinion, a kind of a external court system
Mm.
where there is a decision maker, there is somebody who decides a winner and a loser. These disputes are usually considered non-binding, which means that if the losing party doesn't like that decision by the arbitrator, they can eventually try to appeal to the public court system. But it helps avoid the overflooding of the court system.
Mm.
But that mechanism was already in place. But what the statute did a few years ago is it gave people a choice. They said certain disputes you can now choose not just arbitration, but arbitration or mediation. So, what the legislature, in their wisdom, just realized years ago, which is this state mandated, state funded, private external court system is helpful, but it doesn't work for everybody. And that's where I will tell you that most people, most of our clients, usually tend to go the mediation route. And it's because they don't want a long, hauled out process to try to resolve their differences and have, a power of one decide
Mm.
for them if there's ways to reconcile between the parties.
Yeah, not to mention arbitration can be very expensive. I mean, it's
Absolutely.
more, like you said, drawn out process. There's discovery. I mean, meaning that there's sort of fights that happen internally within arbitration.
Hmm.
If you put them on balance, mediation is a much more effective platform or forum to get these things resolved.
Yeah, so we'll find out. We'll find out what happens with that, and then but the second and final thing, maybe to talk about in terms of this new 2026 proposed, once again proposed, not enacted bill, is that the bill proposes basically a process to better easily terminate condominiums or associations entirely.
So dissolve.
And correct. So dissolve, terminate associations so that nobody has to pay their monthly dues. Nobody has to be enforced by certain silly provisions. Now people can better easily dissolve their associations and live the way they've always wanted to live. I will tell you once again, on theory, I think that addresses the thought that most people have, which is associations are bad and terrible and they don't do enough for you. But I think from a practitioner perspective, once again, I think it creates complications that maybe don't apply to every association.
Hmm.
So walk us through
And
that.
yeah,
Let's sort of walk through sort of how you see this. And I know, Marty, you and I have discussed it. We had a very specific podcast in California based upon dissolving an HOA.
Yes.
And Jeff, I'd like to get your perspective, kind of walking us through, this really hot topic, because I understand where people go, I hate my HOA. I'm so frustrated by it. I want to press the nuclear option. I want to dissolve right now. But assuming you could, what sort of happens on the backside of that decision? What is the aftermath of that dissolving of the association, and what are the practical implications of it? Because that's what I think people don't really, fully discuss, or there isn't a real big spotlight on that.
Yeah.
yeah. I view this termination law or proposal kind of like a murder mystery movie. Okay, let
Do tell. Now I'm at the edge of my seat.
you have the players, you know who's around, you know what's at stake, but then you really just want to fast forward to the end. Okay.
Okay.
So you fast forward
Good.
to the end, and what does that really look like? Terminating and dissolving an association. Okay, well, great. Everybody doesn't have to pay their fair share anymore. Great. Everybody doesn't have to follow the same rules anymore. But then there's this problem where the properties haven't changed. The boundary lines haven't changed. The community areas haven't changed. The common pool, the stairs, that hasn't changed. Who regulates that? Who's there to try to help and say, hey, Joe Schmo took my parking spot for the day. Can you do something, association? There's no association anymore. How if somebody puts their rugs in a stairwell, who moves the rugs? It's a fire hazard. Okay. So, okay, well then fast forwarding to the end in this terrible murder mystery movie. I guess there needs to be somebody to oversee these things. So maybe we try to create a group of people together. Tell me if this sounds right. Let's get a group of people together. Wait, I got a better idea. Let's all just chip in our fair share so that we can have these rules apply to all of us. You know what? But we all work and we all have kids. Maybe we should hire somebody to make sure that, these things are being taken care of on a day in and day out basis. Sending out letters. But man, what if somebody doesn't pay their fair share? How do we enforce that? Man, I guess we got to hire a lawyer too. All of those things, and perhaps many others, sure does now start to sound like an association to me. So the desire to try to dissolve, try to terminate, there are these practical roadblocks that I think make it unavoidable to actually have a fruitful community, desired community by people without having enforcement and interaction, especially when it comes to common areas
Mm-hmm.
and in current infrastructure. So once again, I like the idea on thought. I understand the rationale in thought. I think that in practice, this is a terrible murder mystery movie.
Well, it's funny because a lot of people just say, well, for hundreds of thousands of years, we've never had HOAs. Let's just dissolve them. But they were never really designed to be dissolved in the first place.
Correct.
So you have all these common areas, to Jeff's point, and then who takes care of that? It's not the city's problem. It's the community's problem. The city's not going to say, oh, we'll take them over.
Right.
They were incentivized in the first place to say,
Well, they
hey,
cut that deal
cut
before.
Yeah, they said, "Oh, this is great. We don't have to deal with it. The community's going to deal with it." So what's funny is the whole psychological circle of I want to dissolve my HOA, and you walk down the steps, and all of a sudden you're back to, well, we kind of just built an HOA again. You realize the importance of why it actually exists. Not to mention, well, what does that do to fair market value if all of the people, like, you got in the community in the first place, right? And you liked it because it was well maintained and there was structure to it, and all these Spanish style community, and they all look nice. And then all of a sudden, Joe Schmo is painting their house pink, and this one's going. So the neighborhood starts going, and that affects your fair market value, and it throws away everything that you liked about the community in the first place.
Right. The other big thing too, Jeff, is you often have a mortgage, and there's a instrument, there's a contractual obligation that you have that really turns on this notion that this property is in an HOA. And by dissolving it, you may trigger a breach within your own, mortgage or with your lender very quickly.
Yeah, there are all these, once again, on paper, I think I understand the principle, but there are all these unforeseen, individualized, practical concerns that if implemented will create a unknown territory for a lot of people and a lot of banks.
Yes,
for sure.
Yeah, which isn't the fun part to talk about either.
No,
people like the start of the movie, like the opening, but no one likes to talk about the ending, right?
Just think about all of the lenders and insurance companies. They love the structure that they know that their investment, they're loaning you money, their collateral is protected. At least this neighborhood's going to maintain fair market value.
In theory.
But that's what they signed up for. When they lent you that money, it was under this guise that this was going to be present. Insurance companies, same thing. Oh, there's a pool over there. Oh, now if there's no structure or meaningful corporate structure that protects that, then does it go on the homeowners? And does it open liability up for the insurance? I can see so many potential lawsuits popping up from just the lenders and insurance companies saying, we did not sign up for this in and of itself.
Yeah. And where we landed, ultimately was, if you have a really bad HOA, we understand the sentiment to dissolve, to
100%.
hit the nuclear option.
100%.
But, the practical consequences don't really pencil, right? So there's other ways to approach a bad HOA that doesn't require the dissolution of the HOA.
Yeah.
So
the ultimate place where we landed, it wasn't the structure, it's the people.
yeah, this is often the people that cause the problems.
Yeah,
Absolutely. And I think that at the end of the day, there is this kind of buttoning up where we stand in Florida. There has been this tsunami of riding the wave on behalf of property owners to try to better their rights. I hope that the version of this proposed 2026 bill gets more thought out, and hopefully, in time there are going to be additions, revisions, what have you. But I think it goes to the generalized sentiment that property owners are fed up with a lot of things.
yeah.
And I think this is once again very property owner driven, and so I think that this tidal wave is just continuing, and we'll see what how this bill ends up and how it's voted on for sure. We're going to keep a very close eye on it.
Awesome, Jeff. Well, Jeff, to wrap this up, any final thoughts?
I think that at the end of the day, people need to know that the state of Florida has been doing a lot to protect you. They've been doing a lot to promote your interests. They've been doing a lot to force transparency and accountability to some who have never had accountability. And now bringing forth the transparency to expose the associations when they're not doing good, when they're doing bad. And so people say that there are a lot of bad HOAs out there. My job is to prove it. And so I think for everybody out there, take these rights that you've been given and use them. The Florida legislature has been investigating. They've been working hard. They've been voting, all because they generally do want to see improvement in your way of life. And taking advantage of these laws, not only from a statutory perspective, but taking a look at your own community documents, your governing documents, that's a good place to start if you're starting to have your antennas up and think that something's wrong.
Jeff, so well said. Thank you so much for joining us. It's always a pleasure. I know the audience just loves it, and hopefully we see you soon. You're back on the show.
Absolutely. Thanks again for having me. I really appreciate it. It's always an honor and a privilege, especially to be with the two of you guys.
Well, thank you, Jeff.
Thanks, Jeff.
Marty, thank you.
Thanks, Luke.
Thank you. And again, if you like the show, please give us a like, subscribe, and leave comments. We love the comments, and we know this is a very popular episode, so let us know what you think about these new rules, these new regulations, Florida's direction. And again, thank you for watching, and we will see you next time.